Hello, everybody, and welcome to the Aspen Author webinar series. Today's topic is the case for undergraduate legal writing. Before we begin, I have a few housekeeping items to review. First off, the audio for this webcast is through your internet only, so I highly recommend you use a headset, earbuds, or listen to this presentation through your laptop or mobile speakers. Secondly, this is a one-way communication channel. You can hear us, but we can't hear you. So I do recommend if you have any questions to please use the chat feature on the side. And now I will hand it over to Stacy to introduce today's presenter.
Thank you for joining us, everyone. My name is Stacy Goosman, and I am the managing editor for our undergraduate list. And I'm so excited to introduce you to Antonio Elefano. He's an associate professor in the at the University of Southern California's writing program. He holds a Juris Doctorate from Yale Law School and a Master of Fine Arts from Boston University. He's taught legal writing to undergraduates since 2014 at USC. In 2019, he was one of 3 professors across the university awarded the USC Mentoring Award for mentoring undergraduate students. He's the faculty advisor of Phi Alpha Delta, USC's pre-law fraternity, as well as the faculty advisor and coach for USC's undergraduate moot court team. Before coming to USC, he was a corporate litigator in New York City and a writing fellow visiting assistant professor at the University of Houston. Antonio is also a fiction writer whose stories have been published in the Los Angeles Review, 236, and the Journal. In August of 2014, his story, Italy, was one of BuzzFeed's 29 short stories you need to read in your 20s. So without further ado, I introduce you to Antonio Elefano.
Thank you, Stacy. Good afternoon, everyone. Thank you so much for being here this afternoon. Again, my name is Antonio Elefano. I'm the author of Aspen's legal writing for the undergraduate. As Stacy mentioned, I've taught undergraduate legal writing. This is my 9th year now to teach it at the University of Southern California. It encompasses a few courses. I teach an introduction to legal writing course, and that's going to be the primary focus of today. But I also teach a moot court course and also a course in advanced legal writing. So today's agenda is fairly straightforward. I'm going to start by talking about the benefits of teaching legal writing to undergraduates. And then I'm going to talk about how I approach teaching legal writing to undergraduates. And then we'll have some time at the end for any questions that you might have. So first I want to talk about the why do this? So when I started at USC, I got the assignment in my second semester to teach undergraduate legal writing. There was a professor who'd been teaching the subject for a few years. He was about to retire, so the idea was maybe I could take over. And I'll admit, I was a little bit skeptical about doing it. When I was an undergraduate, I didn't have a course like this. And I remember the rigor of my legal writing courses in law school. And so the challenge was how to translate that to something that was accessible to undergraduates. I certainly had a few assumptions about what I was about to step into. And one of those was that all of my students, of course, would be just pre-law students, right? Would be people who were about to go to law school. So the way it works at USC probably is similar to the way that it is at other universities. Every student has to take both a lower division and an upper division writing course. So freshman composition course. And at USC, those freshman composition courses are divided by various thematics, things like identity and diversity or something like that. But for the advanced level courses, which people take typically in their junior or senior year, the advanced courses are divided by discipline. And here is just a sampling, this is from 2017, of the breakdown of all the advanced writing courses at USC. And the breakdown is pretty similar today. But as you can see, there are a lot of different options, right? So students can pick what translates best into their particular plan, into their particular major, into their particular career path. So again, given the relatively small piece of the pie that is represented by pre-law, my thought was, well, okay, I'm training students to get ready for law school, and the benefits to prospective law students, I think, are fairly clear, right? They learn how to read the law. They can learn the Socratic method. They learn how to apply the law. They learn how to write like lawyers. On top of that, I recently spoke with a pre-law advisor who discussed with me an LSAC pilot program that was happening, where they were coming up with potential alternatives for the LSAT. And so there's some talk about how undergraduate legal writing and research, how courses in those veins could be part of that alternative. But the best sort of affirmation or confirmation of the utility of this course for me comes from former students who go on to law school and who write me in their first months of classes, where they say, like, it's I'm so exhausted and everything is very overwhelming, but at least in this one course, I feel like a little bit ahead of the curve, a little bit have a little bit of familiarity with the subject matter and a little bit of comfort with the curriculum. And as many of you know from your first year of law school, any moment where you can have that feeling of relief and that boost of confidence can be really helpful. For those who are on the fence about law school, I think that my course either convinces them to apply and to make the leap, or it convinces them to stay away from the industry altogether. And either way, I tell them I feel like I've performed a vital function. The worst thing I think that can happen is that someone goes to law school as a default because they can't think of something else, and then discover they don't like it when they're there. So in a lot of ways, I feel like a legal writing course at the undergraduate level is sort of a litmus test to determine if this is the kind of work and the kind of study that students think they can do. I asked a question because I asked sort of informally in my first classes a question that I asked, and I took a poll in spring 2017, but these numbers are fairly consistent. Even up to today, I asked, who here is considering law school? And the majority of them, right, 2/3 to 3/4, often will say yes, right? I'm thinking about it. I've already applied, or I'm applying now. But consistently, there is a large proportion of my classes, a quarter to a third, who have no plans to go to law school at all. And so those students I always found very curious, because they didn't work any less hard, right? The material is very difficult, and you can't just sort of coast in this kind of class. It's a lot of new stuff. And so they were working very hard, and often their contributions were just as good, if not better, than some of their pre-law prospects colleagues. But it did beg the question to me, why did such a sizable portion of my students who aren't even thinking about law school subjecting themselves to the particular challenges of legal reading and legal writing? Because the course as I teach it is just very different from all of those other varieties of courses. It's much more reading intensive, and the reading is very specialized, and the writing is very specialized. So over the years, I've had occasion to speak with these students, to talk to the students, to check in on them post-class, post-graduation, to sort of see what they were doing and how this course sort of fit into their vision for their future careers. So in terms of the sort of benefits to non-lawyers or people who aren't going to law school, one part of this is that they learn how to read the law. Law is to many sort of a foreign language that we have to encounter almost every day of our lives in some capacity, and students want to have if not like the complete command of it, even if they don't want to dedicate their careers to it, they want to feel somewhat literate in it, right? They don't want to feel puzzled by it. The major I see most often in my classes, the most popular major at USC is business. And while some of those business majors are thinking about law school, there is a large proportion who just want to understand the law a little bit better so that they aren't intimidated by its often strange language, which they know they'll encounter on a regular basis. So another reason why these non-pre-law students take the course is they want to learn how to advocate for themselves, right? Even if they don't want to do that for a career themselves, they recognize the value in being able to do what lawyers do, even if it's just on their own behalf. You know, that it's one thing to know one's rights, but what legal writing teaches you is how to fight for those rights. I remember one student who was driving to campus one day to class, and he got pulled over for an illegal turn. And then a few weeks later, he came to class very excited, and he wanted to show me this 5-page brief that he'd written to the traffic court detailing his understanding of the applicable law and the facts at issue. So students are very excited, and they find having some grounding in this skill to be very empowering. Another skill that students get is they learn how to write professionally. A lot of the documents that lawyers write, memos, client letters, are documents that other professionals write as well. So this class has a utility beyond just the back and forth of a law firm or a court. The substance is very focused, but the utility for writers in terms of how it can apply to other walks of life and other careers can be very, very expansive. Finally, they learn how to write persuasively, right? Law is the art of convincing another, of confronting opposition directly and persuading an arbiter why your argument is superior. It's about having a command of both rules and facts and navigating the complicated intersection between the two. So it's been almost a decade now teaching legal writing at USC, and I still find myself incredibly excited by my mission, ushering students into their future careers, many in the law, but many outside of the law. So that's sort of why I think this is a really useful course, and why that utility goes beyond what seems sort of the most intuitive. But now I want to talk about how I went about this and how I go about this and how I use the textbook, Legal Writing for the Undergraduate. So the first part of my job every semester is to figure out how to bridge that gap between undergraduate and professional instruction. And for me, for a number of reasons, which I'll discuss in a moment, I find that it helps to understand why students have chosen this class, have chosen the particular rigors and challenge of this mode of instruction, especially given that as I showed you, not everyone is necessarily using the class as a springboard to law school, and that there are plenty of other alternatives in the university. It's the rare case in which someone takes my class and just says like, it's just what was available on the schedule, right? They come into the first day, I start cold calling, and then they drop. So if they're in it for a reason, right? So the first assignment that I use, this is actually toward the end of the textbook because it made sense in the sort of logistics of the textbook, but I like this assignment first. It's a personal statement. So right now, for example, right, we're in the middle of fall, and a lot of students are applying to law school. And if there's one document that they desperately want my feedback on, it's the personal statement, right? And diversity statement, and other statements too, but the personal statement in particular. So I remember in my first years teaching the course, I'd say, yeah, of course, send it over, and then more sent it over, then more sent it over, and finally I thought, well, let's just make it an assignment. If I'm going to do this for you, let's make it part of it. But I also found that there was a utility for me in setting up the foundation and thinking about the challenges of the rest of the term, right? Another thing to keep in mind that I should mention, because a lot of my students aren't necessarily going to law school, this personal statement assignment is adaptable. And I tell them, look, if you're applying to apply to business school, medical school, whatever, let's make this an assignment for that, right? You can send me the prompt if it's a different prompt, and I'll use that criteria. If you're applying for a Fulbright or something like that, then send me the prompt for that, and we can use that. So it's an adaptable assignment. The main thing is that I want it to be something that's relevant to them, and an assignment for which they have a stake in its excellence, right? But regardless of whatever it is they choose, or a cover letter for a job is another example. Regardless of what it is they choose, I find that the utility to me is still the same. So first, it allows me to sort of get to know my students, right? Why are they here? What do they want to get out of the experience of the class? And I think that's one of the first things as a teacher, as a writing teacher, because our classes are smaller than these giant lecture classes, we have the opportunity to really connect with our students and to really understand what they're looking to get out of a given course. So I start with that. The other thing, they also get help on a document for which they're already seeking feedback. For the law school personal statement in particular, law school admissions rely very heavily on the intersection of an applicant's GPA and LSAT. But beyond those things, beyond those sort of raw numbers, the personal statement, I think, is one of the most important, if not the most important, additional element of the application, for a lot of reasons, right? One is I think it's a sort of test of their reasoning skills. And so in the same way that it's a test of sort of the reasoning skills for a given school, it's a test for you too, right? As an instructor, to sort of see how students build an argument, right? Most academic essays feel a little bit artificial because students are asked to command topics for which they're just gaining a command themselves. And yet they're invited to sort of mimic the rhetoric of experts. In a personal statement, though, the subject is something for which they are uniquely qualified to write about: themselves, their lives, their experiences, and their observations. It's not a question of research or understanding the literature. It's about curating and threading together pieces of their life story to make an argument about why them to this law school, why this law school, why is it a fit? And so seeing how they navigate those waters, I think, is an important part of seeing sort of their argumentative potential. Another thing beyond that, with regard specifically to the prose and how they craft a sentence, is this is a sort of a short essay, so it doesn't take that long to read, but you can start to pick out writerly strengths and virtues that you want your students to lean into when they move to legal writing, and then qualities you might want them to sort of de-emphasize moving forward. So here you can cheer when someone writes clearly and accessibly, when they use concrete imagery, when they build from known information to less familiar information, right? Those are the kinds of things that you want to point to and say, like, this will help you as we make the leap to the next step. You can also point out things that are potentially problematic as they move on to legal writing. For example, artsy or overly complicated syntax, an over-reliance on abstraction, right? For law school personal statements in particular, right? Students often, they want to move to sort of the grand speech as soon as possible. Things about justice and equity, and those all obviously are part of what drive people to this industry. But often what's lost is the personal part of the personal statement, right? And the connection that students have actually to those concepts and to this perspective field. The work that I do here can work in helping to improve this very important document, and help also pave the way for students to write effectively in the realm of legal writing. Okay, so I start there. So that's the first thing that I assign to them, and it's due pretty quickly in the course of the term. But while they're working on that, no study in legal writing can begin without a grounding in the mechanics of the legal system. And that is the next step in the process. So obviously there are many facets of the US legal system, and the goal should be to give students a sort of functional knowledge of the law so that they can understand the various sources of the law and the weight of precedent and how to prioritize one source of law over another. So I introduce my students. I don't lecture that much, but you can't get around this one, I think. You just sort of go through the hierarchy of law and the Constitution and how statutes have greater weight than case law, and how within case law, within decisions made by judges, certain courts take precedence over other courts, and what's binding and what's merely persuasive. So I think that this is obviously an important thing that especially is necessary when students don't have a grounding in the law or aren't taking any other courses in the law. And for undergraduate legal writing, at least in my courses, there's no guarantee that students are taking anything else regarding law. I might be their only class in law ever, right? So in order for them to do the assignments, they have to have these sort of basics down. So I cover that. Stare decisis is sort of the main concept that I want to convey to them before we dive into reading cases. The idea that courts have to follow their own precedent, the precedent of courts higher than them in the hierarchy. And I actually have a sequence of cases that I really like for this. It's a Supreme Court case about the limits of substantive due process, and then so we go through that, and students have a lot of intuitions about how that case was decided, and a lot of disagreements with the majority, and a lot of them side with the dissent, and it's a pretty lively discussion. And then we move to a Fifth Circuit case where a circuit court is using the precedent of the Supreme Court, is bound by the precedent of the Supreme Court, and students are also there's a dissent, a pretty vociferous dissent there, and students are siding with that as well. And then we moved finally to a district court case, and it's a district court in Texas, which is bound by the Fifth Circuit. And what I like about this case, what's curious about this case, is it's a case that was brought up on a motion for reconsideration. So a judge made a decision in the case, but then because the Fifth Circuit case that the students had just read, because that just came out, the district court actually has to reverse itself on the basis of this Fifth Circuit opinion. And the district court, in reversing itself, has this paragraph toward the end where they basically sort of lament that they have to come to this conclusion, come to this decision. And so I always ask my students, look, this is a federal judge. This is someone who's gone through the process of being confirmed, and in the judiciary, this is an August post. So why does this judge, who believes that this case, clearly believes this case was decided correctly the first time, why is he reversing himself and making the opposite call of what he believes is actually just? And at that point, students get it, right? They've read through the sequence and they say well, because of stare decisis, because even if the judge stayed with their original opinion, the party who would lose in that scenario would appeal. And where does that appeal go to? The Fifth Circuit, right? Who's already made very clear their opinion on this matter, right? And so then students get it, start to understand, okay, this is how it works. These are the limitations of the law. This is how the law builds on itself. This is how the law moves into the future. And the best way to end up with a different outcome than a previous set of cases is to distinguish your case, right? Your facts from that precedent. So once students understand how and why courts bind future courts, then I find that they're ready to start applying the law to novel issues of fact and to tackle their first legal writing assignment, which for me is a legal memorandum. Now, I like the interoffice legal memorandum in particular because it's a very flexible assignment. It's something that might be familiar to students who've worked in some type of office in their lives. Memos can be about anything and to any audience within the artificial firm. But one reason in particular that I like I like the interoffice memo is because it invites students, it asks students to be objective in their take on the precedent. And as opposed to like a piece of advocacy, something that was going for a court, right? If you were assigned a particular side and you're the lawyer, then you're obviously, you're writing to win, right? You're writing for your side and you're being a zealous advocate, and that's how that system works. But what can be lost and what can be difficult to discern as a teacher is seeing if students actually understand if the argument they're making is likely to be successful or not, right? So a legal memorandum, an interoffice legal memorandum where they are tasked with being objective, gives you a glimpse into their thought process and how they are working through the reasoning of the decisions and the precedent and the facts. So for the memorandum, I introduced the structure of a typical memo, and I think what's important in introducing this genre of writing, just like any genre of writing, is talking about the logic behind that structure. Students always want examples of essays, and in fact, the Aspen asked me. I didn't have examples of a memo, and I didn't have examples of like an appellate brief, and finally I said, I broke down. I said, fine, I'll put it in. But then, and I understand the reasons why you want that, right? Because students are, being tasked with writing in this unfamiliar genre, and they'd like something, something to look at as a sort of model. The risk, though, the one thing that can be lost by providing that example is that sometimes students become overly reliant on it. They view it as a sort of template. So right now, for example, there are a few memos that I'm grading right now, and I can tell that they've just basically followed almost the exact sort of sentence structure of like the model memo in the textbook, right? And they're just plugging in, just changing the doctrine of law, changing whatever, and not everything works. Like not everything works as well. So so I think it's important to talk about not just like here's an example of a good thing of a good memo, but to talk about why memos are structured the way that they're structured. Because if students can understand that, if they can internalize the why it looks this way, then I think that you might find that sometimes they can come up with novel approaches that could actually be better than what the given sample is, or better than what even you have in your head as a sort of ideal infrastructure or architecture for an argument. So issues and answers, for example, coming before a statement of facts seems very, very unfamiliar to them, because to them, the statement of facts, the background, that's just the necessary context of a story. That's how you tell a story, right? Something happened, so you tell them what happened, and then like an issue arose because of it, right? But explaining that, in the context of like a law firm, for example, when someone is asking for a memo, it's because they have a very specific question for which they need an answer, and they are most invested in getting the answer to that question. so putting that at the forefront of the memo makes a lot of sense, because that is its reason for being, right? And the statement of facts is often, are often a series of events that the assigner is very familiar with anyway. So what they really want is that answer, and then they want the reasoning behind that answer. So that's why there's a sort of primacy that comes with the issues and answers first. The IRAC structure, I teach the IRAC structure. I know that there are many different variations of this, and some are more granular that go into, like CREAC and expansions of like the rule section, the application section. I teach IRAC because to me it's the most basic sort of structure, and especially because a lot of my students are going on into law school. I think that it's easier for them when they go to law school to add those nuances and variations and gradations later than for me to teach a more granular approach, and then they have to unlearn that. So IRAC gives them the sort of basic structure. It gives them a little bit more freedom to work with, and then when they move out to law school, they'll adjust to their instructors and at that level. But I talked to them about the importance of the adherence to this, not because it's just some sort of holy structure, but because it keeps the analysis focused on the given tasks for that assignment. So if you have a given issue, you give a rule that applies to that issue, and in your application, you have to stay close to that rule, right? I feel like that's the advice that I give most often on a first memo is just stay close to that rule, right? If you do that, you're never going to go too far astray. I think students, when I developed some of the assignment prompts, I put in a lot of facts that weren't necessarily relevant to the law, but they're juicy. They look like things that students are accustomed to seeing on on exams or something, where like this something is wrong, so I have to talk about it. And if I don't talk about it, it just feels like something is amiss. But the way that it works in real life, there's lots of things, like there's worlds of possibility in terms of how you tell a story, but there are only certain parts of it that are necessarily relevant to any given rule or doctrine or law. So students have to curate and figure out what is important and make those strategic decisions and then focus appropriately. So I teach them that. In terms of the sort of arc of assignments, I obviously I start with the sort of least difficult and move to more challenging assignments. And for me, that means expanding the case universe. So I've taught this course with 3 memoranda and then with 2 as well. It depends on sort of your needs and on how you view the arc of a semester. If you teach 3, obviously it gives them more opportunities to write and to just have more practice. If you have 2, then you have a little bit more space and a little bit more time to revise. So I've done both ways. And in the assignment, in the textbook, I have a couple of one case memorandum assignments where they just have to have a command of that one case and they can apply that one case to the prompt, 3 case memorandum, and then 5 case memorandum sequences. The subject matter varies. I try to choose things that I found interesting, that I thought students would find interesting: copyright infringement, religious liberty, substantive due process, free speech. I find that these are topics that students are sort of naturally interested in and invested in. So it makes reading the case law a little bit more exciting for them, and it makes writing the memo a little more exciting for them too. So there's one other sort of fundamental part of my pedagogy, and it's one that's borrowed from my time studying and teaching creative writing. As Stacy mentioned, I have an MFA. After I was a lawyer, I decided to disappoint my parents after all and get an MFA in fiction. I loved my time doing that, and I loved the workshopping experience there because basically how it works in creative writing is, small groups of authors. At the program that I was in, it was just 10 of us. We would read a story or a novel excerpt from someone in a given week, and then we'd write ahead of time for class, we'd write a formal critique, often quite long, 1, 2, 3 single-space pages. Then everyone in the workshop, after they've read and after they've written their critique, they'd come to class and we'd spend like an hour or 2 discussing their reactions to the work. So it's easy enough to sort of see the benefits of this process. Authors get loads of feedback from very diverse perspectives, and the critiquing authors get to hone their skills in close reading and analysis. It's really difficult as a writer, as you all know, right? As a writer, to sort of see the flaws in your own prose and your own argumentation. You're just so close to the text that you can sort of lose perspective really easily. But when you're reading someone else's stuff and you're looking at that with fresh eyes, you can see those logical fallacies a lot easier, right? So it enables you to give that author those fresh eyes that they would probably be able to have with the benefit of time, right? The other thing about creative writing, though, I've taught creative writing workshops before, and there's the one thing that can inhibit a workshop or that can make it really fraught is that there's a kind of emotional attachment, right? It's your heart and soul on a page for these kids, especially undergraduates, right? And then you come to a workshop where you get kind of ripped apart by your classmates because it feels derivative or unrealistic or something. Generally speaking, that kind of attachment doesn't exist in the realm of legal writing and legal writing. I mean, people are invested, right? That people care, they want to do well, and they want to get good grades, but they also just want to do well, right? Like they want to show their peers too that they can do this and that they're ready to enter into this industry. But they're invested in the feedback, but they're less likely to take the criticism personally, which is helpful, and makes this subject matter, I think, actually more conducive to the process, right? I remember when I first started this, I'm thinking like, this is just going to be boring, right? Because like, at least when we're doing creative writing workshops, everyone's bringing in like, you know, their own particular style and their own particular kind of story, and so it's kind of fun to explore all these different things. If we're all responding to the same prompt, like, is that actually going to be worth our time? Are students going to find it really tedious? And I'm in the middle of workshopping right now, actually, my students' work in my intro to legal writing class. And it's the opposite, right? Like, people are really, really invested in seeing how their classmates tackled the same prompt. And because everyone's dealing with the same substance, they don't have to, they understand the basic law. But what they're curious about and what they're really interested in, and what they complement each other on, is how each individual student approached craft, right? And how they approached structure, and how they approached, drafting a statement of facts, and formatting a statement of facts, and how they divided up the analysis and made it clear to the reader, and how they handled counter argument and all these other things, right? And so you end up with these very rich discussions that are very craft centric about legal writing. And so in terms of the sort of nuts and bolts, I follow the same basic process from creative writing. I have students write a critique. So it's not just a sort of like where they just like write a little comment on a manuscript. They write criticism as I write criticism, right? Like a page of feedback, single spaced page of feedback. And so they'll give the author on that given day, they'll give them the essay along with that, that'll be marked up with, sort of grammatical issues, but then they'll have this essay about their essay, and they'll have multiple essays on their essay. So with regard to the critiques in particular, I grade those for effort. So I'm not looking to see if I agree necessarily with the criticisms. I'm just checking to make sure that they're engaging with the work, right? I think it would be monstrous to fault students for criticisms that you don't personally agree with when they're just learning how to do legal writing themselves. So this I'm comfortable sort of grading as a sort of like effort, but students do put in the effort, right? And in seeing the flaws in other people's writing, it helps them to see the flaws in their own, and it helps them to gain strategies for how to write and how to become better writers and how to refine their writing, because they learn these strategies from their peers. And it's also nice that they're learning from their peers too, because this seems like a much more accessible source of like knowledge and wisdom, right? There are lots of texts that have, examples of like great appellate briefs written by like, people who are Supreme Court justices. And that's really great. And that's really helpful. And it's always good to see sort of like master examples of things. But, if someone wanted to like write a short story, you wouldn't, put Tolstoy in front of them and say, here, right, figure it out. There's something about being in a community of writers who are all learning to do the same thing and them doing it together that can really facilitate a feeling of camaraderie and community, where they really help each other. Another thing that I find is that it helps students to see improvement over time. So typically I do 2 workshops in the course of a semester. And the first workshop is the most sort of torturous for students because they're new to the genre, and there's lots of criticism that often happens there because they're all new to it, right? And so maybe there'll be a few essays that are really exceptional, but most are sort of feeling themselves out, right? And making mistakes as anyone would when entering into something new. But then they'll see a later memo, which is a harder memo, which has more law and is more complicated, but now they have familiarity with the genre, and now they have the benefit of all that feedback, and now they have the experience of doing it before. And the result is that there's, for almost everyone, a significant improvement in that second memo. And so then when we workshop that second time, it's a wonderful feeling for students because they feel like they've improved, and their peers can affirm that for them, and I can affirm that for them too. And then they see that improvement in their peers, and they see everyone getting better and learning. And so it's nice whenever they can see not only the benefit to themselves, but the benefit to their cohort. And one more quick thing about the logistics. USC advanced writing classes are capped at 19 students. So I split the class in half, and I do 10 students workshop on one day and then 9 students on another day, and then we alternate. So they have a few days off when we're workshopping, and that's the sweet spot for me in terms of the number of people. You don't want to have too many people, too many voices. I mean, in a room, but that's a good spot for me for creating a thoughtful environment and not overloading students with reading too many essays. So I hope that you'll consider integrating this into your curriculum. I know it's a little more involved than I think most peer review processes are, but to me, nothing conveys the primacy of student writing more than dedicating weeks to close reading every single submitted paper. And as I said, it helps to facilitate community building among the class as they see themselves on this sort of journey together, struggling and then often succeeding to meet their objectives and to harness their potential in this really strange, really scary at first genre. So the textbook, Legal Writing for the Undergraduate, it covers other territory as well, including legal research and appellate brief writing. But I personally save those subjects for my advanced legal writing course. So I'm going to save that perhaps for another webinar. And I also wanted to leave some time here for your questions if you have any. But before we do that, I just want to convey again how really skeptical I was when I first got the assignment to teach legal writing to undergrads. I was terrified. I remember my legal writing classes. I liked my legal writing classes. That's what I felt, sort of best at in law school and best at as an attorney. But I don't know. It hadn't occurred to me until I was forced to do it, that it was something that could be effectively done at the undergraduate level, and that had a utility, and that it had a utility beyond just sort of giving people a little bit of a leg up before law school. Over time, that skepticism, quickly eroded. And I saw just how motivated and inspired my students were, not just the ones who were going to law school, but the ones who were taking it purely out of curiosity or because they thought that it might help them in their future careers. I have students who, for example, journalists who get plum assignments covering courts because they're the only person, they're one of the people in their organization who can read a case and can understand what it means and can interpret it and can ask the right questions and can interrogate the opinion and understand its sort of significance. So it's wonderful to be able to teach something that has a more expansive effect and that presents more opportunities than even I imagined when I started. I tell my students every semester that my job is the best I've ever had and the best I could ever imagine for myself. And the thought that I could help start or facilitate for others what has been so personally and professionally gratifying to me is just beyond incredible. So thank you for listening. Thanks to Aspen for arranging this. And I'll invite Allison back. And I'll take any questions that you all might have.
Wonderful. Thank you so much for your presentation. We have entered the Q&A portion of today. So if you have any questions, I highly encourage you to type them in the chat and I will read them out loud. Looks like we have a few to start with, so why don't we get started? So first off, what is the biggest writerly problem you see in student papers when undergraduates make the switch from undergraduate writing to legal writing?
Sure. So the biggest problem that I see is represented by a marking that I put on the paper. It's OW and ow, right? Like so it actually stands for overwriting, but it also is like, ow, this is actually hurting my soul. And I think that it comes from a couple of things, right? It comes from reading a lot of like academic work where it's a very where the syntax and like the discourse is just very high, and so they're accustomed to being part of academia, and so part of being an academic is sort of looking the part, and so they write prose that looks smart, that they think looks smart, but is not very clear, and that's very counterproductive for the purposes of what we're trying to do and the objectives of this course, right? So one thing that I always tell my students is that the law is complicated, right? It's a hard thing to navigate. There is a very rare case in which a legal issue, especially one that would go up to like an appellate court, is just so simple that it can be explained, in just like a paragraph or so. So the law is complicated. Keep the syntax, keep the language, keep the prose as clear and concise as possible. So that's I think one of the main things. The other thing is that they use as a model sometimes the actual court cases that they're reading, some of which are not written the best, right? And some of which are also sort of inaccessible. And so they think like, well, I have to write the same way, or they try to replicate the syntax of like a Supreme Court justice. And that's also an invitation for disaster, right? Because they're just learning this genre themselves, and so sometimes they're overly reliant on the cases themselves. They're over quoting, or they're just not integrating things well, and they're just not inserting themselves because they feel timid, right? So it's about at the beginning, it's a little bit about giving them the freedom to sort of just make a mistake, and to make an argument that might not be successful, but that at least I can recognize as their own thinking, as opposed to just sort of trying to snow me with just like jargon, or with just like cobbling together excerpts from a case and then presenting that as if it were their sort of original work. So those are the main issues.
Thank you. Next question is, how long does it typically take to workshop one legal memorandum?
So it depends on the course. It depends on the course and the time constraints of a particular section or whatever. So ideally, 15 to 20 minutes. You're going to want to spend more time. You're going to want to spend more time with this at the beginning and those first workshops, because you're probably going to have more criticisms, and you're going to have the workshops will probably be shorter. Hopefully if you've done your job correctly, it will be shorter at the end, because people will be better and there'll be just fewer things to cover. But at the beginning, at least 15 to 20 minutes per essay is normally really helpful.
Great. We have one more question, or another question.
Yeah.
I can see the use in English and journalism, but how do you get an instructor that doesn't meet minimum qualifications to teach a course? Sure.
So I have some colleagues in my writing program now who, if I understand the question correctly, who aren't lawyers, but are teaching pre-law sections just like I am, and so but when they're teaching these courses, some of them. So what some of them do is they default to sort of like, well, I'll just sort of teach an academic essay about legal topics. But a lot of them want to delve into legal writing and how to do this and the conventions of it, because a lot of they see that a lot of students want that. And so what I tell them is that I was daunted about entering into this genre myself, even as a lawyer, because the law is so expansive, and because I don't consider myself an expert in any area of law, much less all the areas of law. And I had this sort of nightmare scenario where students were just asking me questions about torts and whatever. But what I told those professors who wanted to teach this was that it all that's required for accessing a particular assignment is getting a command over a universe of cases, like a closed universe of cases. So for given assignments, right, I don't allow my students to do research for my intro to legal writing class. I don't want them to go outside of a given prompt. And then that enables me as an instructor to just focus on that universe. And then when I was helping my fellow professors at USC tackle the assignments, they were less daunted about the idea of, all right, for this one case memorandum assignment, I just need to understand this one case, right? And then and if they have a command over that, and then the conventions of the genre, then they can tackle that, even if they don't have a background in law or feel comfortable outside of that closed universe. Oh, I see. Okay. I see the next question. I'll go ahead and read it. Is that okay, Allison? Sorry, Lynn. I apologize if I didn't. So she means people who are lawyers who might be teaching the course, but want to put the courses in English and communication, specifically at the community college level. Okay. So how might one adjust the course then for courses in English and communications? I think there are a variety of ways to tackle it. I mean, to consider the legal memo as sort of an extension of professional writing and English courses in particular, as just an opportunity to tackle it in a specific genre. With regard to communications and to oral advocacy in particular, I coach our school's moot court team, and students get really excited about competing on this level. And what's really unique about competing in appellate oral advocacy as opposed to other types of advocacy is that judges fire questions at you sort of on the spot. And so your reasoning gets tested in the moment. So I find that exercise in particular, for a lot of I have communication students as well who take the course and who find this kind of thrilling, right? Because they sort of like being on the spot. They like sort of showing off how quickly they can think on their feet. So this gives an opportunity, again, a closed universe of case law and a given scenario where they can spend some time to really get a mastery and feel like they have a command of that specific fact pattern and that specific case universe, and then and you can really sort of test their how quickly they can think on their feet and how quickly they can sort of build an argument off of a judge's concerns about the particular original case that they've submitted or presented to the court.
Thank you. At the time, I don't see any more questions, so I will pass it back over to you for any sort of final remarks. And I thank you again for doing this presentation.
Of course. Thank you so much for having me. Thank you all for attending this. Again, as I said, I love doing what I do. It's sort of a privilege to end up in a position, in a sort of dream position that I didn't even know existed when I started my career. And I can't thank you enough for taking the time engage with me today and to listen to what I had to say. And I can't thank Aspen enough for giving me the platform and the opportunity to do it. So I hope this has been helpful. If on the screen here, you'll see my my email address. I'm happy to chat at length with anyone who wants to talk about the particular challenges or particular opportunities for ways to teach this class. It's been I think it's been really beneficial to the students that I teach. And Lynn said fight on, and fight on. I'll end with that. So so thank you all so much, and have a wonderful rest of your day.
Wonderful. Today's webinar has now ended, and thank you very much. I hope you have a great rest of your day.